Hi, thanks for joining us for today's webinar, Embedding a Human Rights Culture, Where to From Here. My name's Penny Sullivan. I'm part of the Capacity Building team at Community Legal Centres, Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I pay respect to their elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As this webinar is being viewed by people across Queensland and around Australia, I also pay respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people listening today. So this afternoon, we're really pleased to welcome Rebecca Leong, who's the Principal Lawyer at the Queensland Human Rights Commission, to refresh our understanding of the Human Rights Act, focusing on the obligations of public entities to act compatibly with and give proper consideration to human rights. We're also going to hear from our CLC colleagues Ellie Dalton and Helen Blaber about using human rights in advocacy on behalf of clients. So I'll let Rebecca introduce herself and Ellie and Helen when I hand over in a moment. Before I do that though, just some quick housekeeping. Today's webinar is being recorded and we'll have that recording available to download later today or tomorrow. The PowerPoints are available from the handout section of the GoToWebinar control panel, and I did email those slides out to all people who registered before the webinar. We do encourage you to ask questions. Please type your question into the question box on the control panel and we will read your question out at the end. Please feel free to type them in as you think of them though. So that's it from me for now. So I'm going to hand over to Rebecca and I'll talk to you again at the end of the session. Thanks, Rebecca.
Thanks so much, Penny, and thanks for the invitation to speak with everyone today. And it's great to see so much interest in this topic. Before I begin, I'd like to echo Penny's acknowledgement of country and pay my respects to the elders of the Turrbal and Yagara people, which is where I'm meeting from today. And I pay my respects to elders past, present and emerging, and extend that respect to any Aboriginal people or Torres Strait Islander people joining us today. A quick overview of today's presentation. So as Penny already said, we're going to rush through some of the key points of the Human Rights Act, and then I hope to get to the main interest for today's topic, which is to hear from our advocates on the ground in relation to their experiences in conciliation before the Queensland Human Rights Commission, and also using human rights in the courts. And then the final part of today's presentation, we will have a brief panel discussion about reflecting on what could be improved under the Human Rights Act, what are the challenges under the current Human Rights Act, and some tips for advocates. And I'd really encourage participation in that part of the presentation. Throw in your comments and your questions at that time. So quickly about the Human Rights Commission. Our staff, we're currently sitting around 60 full-time staff, and we have offices in Cairns, Rockhampton, Townsville and Brisbane. The majority of our staff are complaint handlers, conciliators, and they manage complaints received from people complaining under the Human Rights Act as well as the Anti-Discrimination Act. We also have small teams that do project work as well as community education and training to try and increase knowledge and understanding of human rights in the community. And we also do some law reform work in terms of making submissions to Parliament and intervening in court and tribunal proceedings to assist them in their understanding of the Human Rights Act and its application. And I'd encourage you, if you hear anything today that you are more interested in hearing more about, we have a lot of training packages that we can tailor to your needs, and I'd encourage you to have a look at those online or even reach out to me and I can definitely talk you through what the options might be for you. These are the objectives of the Human Rights Act. It basically sets out Section 3 of the Human Rights Act. But what I do wanted to draw your attention to was that second bullet point, helping to build a culture in Queensland public sector that respects and promotes human rights. And that particular objective has been drawn into the terms of reference that will frame the 4-year review of the Human Rights Act, which is coming up. So that's one that's expressly been captured by the terms of reference. How the Human Rights Act achieves those objectives, it's through a dialogue model. A dialogue model favours discussion, awareness raising and education about human rights, as well as the everyday interactions of individuals with government, and it places obligations on Parliament, courts and tribunals and public entities. The rights that are protected, there are 23 sections that set out the rights that are protected under the Human Rights Act. These are all drawn from international instruments, and there are 21 civil and political rights and 2 economic, social and cultural rights. Just because there are 23 sections, though, doesn't mean that there are 23 rights protected. Some of these rights are quite far-reaching and perhaps expand further than what their headings suggest. So I would recommend that people who are practicing in human rights have a good read of the rights that are most relevant to them. And I would also recommend having a look at the explanatory notes to the Human Rights Bill, which is a very useful tool in understanding what the scope of the rights are intended to be. The Human Rights Act talks a lot about compatibility. This term compatibility, public entities need to act compatibly with human rights. Legislation needs to be interpreted compatibly with human rights. And so it's a really important key term under the Human Rights Act. And what it means is that we have rights, which was on the previous slide, and an action or decision or a statutory provision is compatible with human rights if it does not limit a human right, or the right is limited only to the extent that is reasonably and demonstrably justifiable. So the point is the Act protects human rights by prohibiting unjustified limitations of human rights. The Section 13 of the Human Rights Act sets out the factors that should be considered when deciding whether a limitation of a right is justified or unjustified. And those are the steps set out in short form on the right-hand side of the slide there. There are 5 factors that are set out in Section 13, subsection 2. The first one is whether the decision or action is lawful. It has to have legal authority to be making the decision. Is it have a legitimate purpose? So what's the purpose of what is the purpose of the limitation? Is it a legitimate purpose? Will it achieve that purpose? And that's the rational factor that I've listed there. Is the limitation necessary to achieve that purpose, and will it be achieved in the least restrictive way? And finally, taking into account the purpose, the importance of the purpose, and the importance of the limit, the importance of maintaining the right, having a balance between those two, and seeing whether whether the balance weighs in favour of protecting the right, or the balance weighs in favour of imposing the limitation. So that's compatibility in a nutshell. For advocates at community legal centres using the Human Rights Act to protect their clients' rights, the main consideration for you, I imagine, is what are the obligations of public entities under the Human Rights Act. So there are 2 obligations under Section 58. The first is that they must act and make decisions in a way that's compatible with human rights, and we just talked about compatibility on that last slide. But there's a secondary obligation to give proper consideration to human rights when making decisions. And what proper consideration is it will be unlawful for a public entity in making a decision to fail to give proper consideration to a human right relevant to that decision. And under subsection 5 of Section 58, there's some guidance as to what proper consideration means, and I've set it out fully in the slide there. That particular guidance is unique to Queensland law, so you might be aware that there are human rights legislations in Victoria and ACT. They don't have these guiding principles within their acts, so that is unique to Queensland. The other issue I just wanted to touch upon is that even if a public entity acts in breach of their obligations under Section 58, it doesn't necessarily mean that it invalidates the decision. The court has to still declare that the decision is unlawful and unenforceable, and that is set out expressly in section 58 subsection 6. And just as by way of case example, you might be aware of the recent court case in relation to the vaccination mandates. And in that case, the QPS commissioner, the police services commissioner, had imposed a vaccination mandate on police officers, and the court determined that the police commissioner had failed to give proper consideration to human rights in making that vaccination mandate, and on that basis declared that the vaccination mandate was unlawful and unenforceable. And that was even though after going through a compatibility assessment, the court was satisfied that the mandate itself was compatible with human rights, but the failure to give proper consideration was sufficient to declare it unlawful because of a breach of section 58. Turning then to human rights complaints made to the Commission. So there's no standalone cause of action for a breach of human rights. You can't go to the court and just say my human rights have been breached and bring a cause of action that way. The only way to bring, I guess, what you could term a direct cause of action is making a complaint to the Queensland Human Rights Commission. So a person who is aggrieved by a decision of a public entity and the allegation is that the public entity has breached the individual's human rights, they can make a complaint to the Commission, and the Commission's role in receiving that complaint is to try to resolve the dispute, usually through conciliation. Parties can agree to any outcome that they wish, but because a complaint made to the Commission can't go any further than the Commission, there's no referral process to a tribunal for determination or to a court, the chances of getting a financial outcome are unlikely. The one outcome that can be achieved if the complaint is unresolved is that the Commission can prepare a report on the unresolved complaint and make recommendations about actions the public entity should take to ensure its actions and decisions in the future are compatible with human rights. We publish all our reports made on unresolved complaints on our website. We don't do them terribly often, but our experience has been when we do, they have been picked up and changes have been made as a result. In this slide, I just set out the key steps in bringing a complaint to the Queensland Human Rights Commission. The main point here is that before making a complaint to the Commission, complainants have to first attempt to resolve the complaint with the public entity first, at first instance, and then so submit a complaint to the public entity and then wait 45 business days before making the complaint to the Commission. Those 45 business days, though, can be waived in exceptional circumstances. The other thing to note, and I think Ellie will talk more about this, is that when making a complaint to the Commission under the Anti-Discrimination Act, which doesn't require initial complaint to the public entity, a human rights argument can be piggybacked onto a complaint of discrimination, and that human rights complaint can actually be determined at the tribunal if the discrimination complaint is referred from the Commission to a tribunal for determination, so they can further determine both the discrimination component and also determine any human rights grounds that are raised. I'm just going through some quick statistics on complaints that we received through 2022 to 2023. These are obviously a little bit dated now, but I'm told that they are reflective of the whole 4-year period that we've gone through since the commencement of the Human Rights Act. You can see that we were largely overrun by COVID-19 related complaints. 44% were related to COVID-19. These are also a combination of both well, the human rights complaints. When we talk about human rights complaints, we mean both pure human rights complaints that are only just made under the Human Rights Act, but also anti-discrimination complaints made against public entities where human rights have been piggybacked. And so you can see the statistics there, and you have access to the slides so that you can look at them later on. Here, resolution rate by complaint type. So only, unfortunately, 50% of any discrimination complaints were resolved. That's compared to piggyback complaints. So those are complaints made against public entities. Only 20% of those are resolved. I'm not too sure what our analysis is of that as yet. And also 32% of pure Human Rights Act complaints were resolved. The main human rights that are engaged is equality, and that's understandable since the right to equality are going to attach as piggyback rights to all anti-discrimination complaints. And then the following top right that is raised is the right to privacy, which is also understandable since it's one of the broadest rights under the Human Rights Act and was largely affected by COVID-19 restrictions. Finalised complaints by sector. So corrections is the highest, it has the largest number of complainants, and I think that is reflective of the fact that in the corrections space, prisoners need to, there's another process that needs to be undertaken for prisoners to make a complaint under the Anti-Discrimination Act, which doesn't exist under the Human Rights Act. And so perhaps prisoners are more encouraged to make a complaint under the Human Rights Act. And then the complaints against health as a second top sector where we receive complaints is also reflective of the high number of COVID-19 complaints. Legal representation. So you can see for anti-discrimination complaints, 30% of anti-discrimination only complaints were represented. Only 21% of piggyback anti-discrimination complaints were represented, and then only 7% of human rights complaints were represented. And so perhaps that shortfall of representation in the piggyback space might account for some of the results that we obtained in terms of resolution at the conciliation stage that I showed you on the previous slide. And that takes us to our first presenter, Eloise Dalton, who's the Acting Director at Working Women's Queensland Basic Rights Queensland. And I'd invite Ellie to take off her mute and share her experiences as an advocate in the Queensland Human Rights Commission conciliation space.
Thanks, Beck, and good afternoon, everyone. So for anyone who doesn't know Basic Rights Queensland, we have a few different practice areas, so including social security, employment and disability discrimination. I'm in the Working Women Queensland team, and we do a lot of work with both the Anti-Discrimination Act and the Human Rights Act, as does our disability discrimination team here. So I thought I would just preface my contribution today by pointing out that most of the clients that we see and we advise face intersecting forms of discrimination. So this means that when they come to see us, they've got multiple causes of action available to them. And what that means is that ultimately any human rights argument is almost always piggybacked onto another complaint. And often the human rights argument is the least meaty, I guess, of all the arguments that we might make. So in some of the cases where a contravention of the Anti-Discrimination Act is really significant, the human rights argument is almost added for completeness, and that's not necessarily a good thing because there might be a really important human rights argument that could be made, but it's sort of swallowed by the more egregious contravention of the ADA. But I'd say this happens because of the remedies available in a human rights complaint, given that they're more limited. So, for example, in a complaint involving sexual harassment, that momentum that we're seeing in awards of general damages really blows a human rights complaint out of the water. The other thing I thought I'd just mention is that we would rarely, if ever, run a pure human rights argument which is supported by the data that Beck has got in her slides. So the most common rights we interact with are again supported by those slides. We see most often the right to recognition and equality before the law, the right to privacy and reputation, and the protection from torture and cruel, inhumane or degrading treatment. In our experience running human rights complaints, we find that the typical response from a public entity is to either let the 45 days lapse without responding at all, or if they do provide a response, it's to argue that there was no limitation of a right, or that limitation was reasonable. And our experience really depends on which public entity. Some are more responsive to human rights complaints than others. So I've brought a couple of examples with me to illustrate those responses. In my first example, we supported a client who worked for a public entity, so it was through the employment practice. The client alleged that there'd been some pretty horrible conduct in the workplace, which would have amounted to impairment, discrimination, sexual harassment, sex discrimination and victimisation. So it was a bit of a bingo card in terms of different options available to this client. The client wasn't in a big rush at that point, so we assisted them to first lodge a human rights complaint with the public entity to see if it could be resolved internally. In terms of the response to that human rights complaint, we got an order reply confirming receipt, but then didn't get anything again until 50 business days had lapsed. And the response at that point was essentially to repeat that the public entity had received the complaint and that they were now considering the material. In the meantime, the public entity became aware that we'd lodged a complaint with the Queensland Human Rights Commission in relation to the other conduct as well. And the public entity essentially wrote to us saying that they would now engage in the Queensland Human Rights Commission process and not comment further on the human rights complaint. So I thought I'd share this as an example of where the time period elapsed without any real engagement at all by the public entity, and pretty much no engagement in any dialogue about the human rights complaint at all. And from the client's perspective, that lack of engagement was just another additional source of frustration because they experienced that through their employment as well. They felt minimised and ignored, and having that response to the human rights complaint really compounded that feeling. But this matter ultimately did resolve at a conciliation, and while there were monetary but also non-monetary remedies, it was made very clear to us that the settlement was on a commercial basis. And in reviewing that, that makes us think that ultimately it wasn't the human rights argument that motivated a settlement. It was the arguments about the discrimination and the sexual harassment that got us there in the end. And our other experience at conciliation with this matter is that there was such a lot of material to discuss that the human rights arguments really took a back seat at the conciliation. So in that first example, the human rights complaint process was not particularly useful, but we have had experiences where it has been more useful. So in a different example, and this was with a different public entity, which of course has an impact, this client had multiple impairments and needed specialist disability accommodation, and a decision was made by a public entity that ultimately meant that accommodation was brought to an end, and a human rights complaint was first made to that public entity before anything else took place. The complaint to the public entity at that time was really detailed, and it called for really specific outcomes even at that initial stage. And unlike in the first example, the public entity was very quick to respond. They responded promptly and were quite detailed in their response. Ultimately, the public entity argued that there was no limitation of human right, and even if there was, it was justified. But it gave us an insight into what the public entity and the respondent to a QHRC complaint would argue at conciliation. So in that matter, we then assisted the client to go on and make a complaint about discrimination and piggybacked the human rights complaint to the ADA, and it was resolved at conciliation. So from a tactical point of view, again, that human rights argument was more useful than in the first example I shared, because it gave us the inside scoop, if you like, to the arguments that would be made by the respondent. But additionally, in terms of the client's experience, it gave them some language around talking about how unfair the treatment they'd suffered had been. It was, again, an additional source of frustration that the public entity didn't really engage in the human rights complaint process. But having that language was certainly useful, as we have experienced that some of our clients can become a bit disengaged if we're engaging in really legalistic arguments about discrimination, but that human rights language can be more accessible. So Beck, I'm just going to pass back to you. There are two examples that thought I'd share in relation to our experience running human rights complaints.
Fantastic. Thanks so much, Ellie, for that insight. And I hope people today can find your experiences really useful to go forward with. We then turn to, if I can get my slide deck working again, talking about courts and raising Human Rights Act arguments in courts and tribunal hearings. So I already spoke briefly about the fact that the Human Rights Act doesn't provide people with a standalone cause of action within which to make a complaint. They have to argue human rights in a different way. And one of those ways is the piggyback that Ellie spoke about, and attaching it to an existing cause of action, such as a complaint under the Anti-Discrimination Act. There are other ways you can raise human rights, though, in courts and tribunals, and that includes arguing that a provision of a statute requires an interpretation that is compatible with human rights. There is also situations where the court or tribunal is acting in an administrative capacity, and in those cases, the court or tribunal will be a public entity with obligations under Section 58 in the same way other public entities have those obligations. And then there's also the ability to argue that a court or tribunal must directly apply human rights, and that's under Section 5, and that probably takes a whole presentation in itself to unpack. But those are the four ways that I've identified as raising human rights in court and tribunal proceedings. These are just a fairly random sample of cases that have discussed human rights in more detail. In our 2022-23 annual report, so the Commission prepares an annual report on the Human Rights Act each year, and we do a fairly detailed analysis of court cases that were heard in that financial year. And I note that for 22-23, the number of cases that refer to human rights were more than double the previous year. So the discussion of human rights in courts and tribunals are gaining momentum. The Owen Darcy case is one that Helen, our next speaker, was involved with, and that was a piggyback case. So human rights were piggybacked onto a judicial review. The Waratah coal case before the Land Court was one of those matters where the Land Court considered itself a public entity acting in an administrative capacity, and so it had obligations under Section 58 of the Human Rights Act to act and decide compatibly with human rights and give proper consideration to human rights. And then the Johnston and Commissioner of Police matter was the vaccination matter I previously spoke about, and again, that was a piggyback judicial review. And so I might now invite Helen Blaber, who's the Director and Principal Solicitor of Prisoners Legal Service, to provide some of her thoughts and experiences in using human rights as a tool in courts.
Thanks, Beck. I'm hoping everyone can hear me okay. Okay, so what I thought I'd talk about is something that we are constantly dealing with and thinking about at PLS in relation to piggybacking human rights matters onto litigation, and that is the evidence gathering component, which is what you as the solicitor will often, if you are a solicitor, going to have to be doing. So essentially the things that we are often thinking about is when should we adduce evidence and what evidence should we be trying to adduce. Most of the human rights litigation we have run to date is judicial review applications in the Supreme Court. So I'll speak about it in that context, but I also need to just say I'm not an expert, and these are just, I guess, my reflections on the experiences that we've had so far. So So far, we've filed 5 judicial reviews in the Supreme Court with human rights arguments piggybacked and 1 in QCAT. The first one we did was the Owen Darcy decision, which proceeded to hearing and was successful on both the procedural and the substantive grounds. The other 4, sorry, there were 6, 5 JRs and 1 QCAT. So the other 4 judicial reviews never made it to court. The decisions were rescinded prior to the hearing, so there's no published decisions of those, but we got good outcomes for the clients as a result of filing that litigation, but no precedent decisions. The QCAT one we've got is still on foot, so that's still going. But I guess what we have been learning as we're doing this is, if you're running a judicial review with human rights arguments, it's so important to think about what evidence you want to ensure is before the court, and to be thinking about that at a really early stage, ideally before a decision is even made, if that's possible. Depending on the arguments that you're going to be making, it's probably going to be a lot more onerous for you running this litigation than just a standard judicial review, partly because of this evidence gathering component. So when you advance arguments for any judicial review, you always want to make sure as much information as possible is before the decision maker, before they make the decision. And that's because you'll often be arguing that they failed to take into account something that they should have taken into account. But if there was no evidence before them, then it might not be possible for them to have taken that into account. That reasoning seems to now be being extended to the procedural limb being made for human rights arguments. So in the Johnston decision that Beck mentioned on the earlier PowerPoint, Justice Martin talks at paragraphs 22 to 29 about the timing of what was before the decision maker and when. And he says that if legal reasonableness is to be assessed at the time the relevant decision was made, then there are strong grounds for applying the same reasoning to consideration of matters under the Human Rights Act. So he goes on to talk about, if you're failing to give proper consideration to a human right, that failure can only occur before or at the time of making the decision. And that all makes sense. That's all in line with normal judicial review type stuff. And most of the judicial review arguments we have filed, the strongest arguments have been that the decision maker simply failed to consider human rights. So the evidence was pretty straightforward in that the decision-making record or the statement of reasons gives you the evidence that you need, which is, well, here's the evidence that the decision maker has not considered human rights because there's an absence of any reference to human rights in the statement of reasons or the decision-making record. So that's not particularly onerous. If you've got a decision-making record and you know can demonstrate that the human rights were relevant to be considered, then that's fine. You've got the evidence you need to hopefully succeed on the procedural limb. Where I think it gets more complicated is if you're arguing a substantive breach. And the cases where we've been doing that, we have found, and counsel's advice has been, that you want to try and adduce some sort of evidence of the impact of the decision on the client. So in those cases, we have obtained affidavits from the clients. If we're arguing a breach of family life, we've obtained an affidavit from family about how the decision has impacted the family unit. The best example I can probably give you is the Owen Darcy example, because there's material published about that in the Owen Darcy decision. So I thought it might be helpful to talk about what we did, what we didn't do, and what impact that had on the ultimate decision made in Owen Darcy. So what we did was after the decision had been made, and this was a decision to place him on a consecutive maximum security order, which meant that he had then been held in consecutive solitary confinement for about 8 years. After that decision was made, we already had a whole bunch of documents and decision-making records, and we'd done arguments about why it was a breach of his human rights, why they should take him off solitary. All of that was before the decision maker, before they made the decision. What we did after the decision was made was we prepared an affidavit, a 12-page affidavit from Mr. Owen Darcy to try and explain why is this so bad? Why does putting somebody in solitary confinement for 8 years breach their human rights, rather than just trying to assert that it just does? So what we did is we went through a whole bunch of international case law and the national case law that exists in relation to solitary confinement to look at what kind of evidence was considered relevant to demonstrate human rights breaches. We then prepared a range of questions to ask Mr. Owen Darcy that we could then use to put together an affidavit from him. We also did a right to information request to get his medical records, and we went through his medical records and extracted the things in there that we thought helped demonstrate why his 8 years in solitary confinement was so problematic. There wasn't a lot in his medical records, to be honest. There was scraps and bits and pieces about him having low levels of vitamin D and that kind of thing, but nothing hugely, you know, pointing to this person has been damaged because of their 8 years in solitary confinement. Now, what we didn't do is we didn't obtain an expert medical report about the adverse impact that solitary confinement may or may not have had on Mr. Owen Darcy for this 8-year period. There's a couple of reasons we didn't do that. One was limited time. You've got to file a judicial review within 28 days of when you get a statement of reasons. But the other probably bigger issue is limited resources. Getting an expert medical report isn't cheap. And also finding someone with the expertise who can actually go into a place of solitary confinement and do a report about, well, how much of this is caused by whatever this person is experiencing, whatever level of suffering or mental health issues they are experiencing, how much of that is actually caused by the solitary confinement. So we didn't do that. We didn't get that. So what impact did that have on the decision? Well, I think the affidavit we got certainly did help. And I mean, we were successful on the argument that they had breached his right to humane treatment in custody. In the Owen Darcy decision, Justice Martin repeated extracts of the affidavit from Mr. Owen Darcy, which included information about the size of his cell, the walls being concrete and bare with no shelving, his small window with bars that didn't open, the limited amount of natural light, what he could see out of his window, how often he was allowed to shower, how often he was allowed to flush his toilet, where his toilet was located, which was about 45 centimetres from the head of his bed, details about his cell searches, details about his personal searches. We also included what information he could give us about how his time in solitary confinement had affected him. And this also was appears in the judgment. At paragraph 162, Justice Martin extracts the quote from Mr. Owen Darcy's affidavit, which says, "It's difficult for me to describe how these experiences have impacted my mental state. I have become emotionally numb. You end up dead inside." So there's all this stuff, and he talks about the impact of seeing suicides in solitary confinement. So that's his description of how he feels, but it was very difficult for him to identify it even. So the affidavit that we provided, I think, definitely helped us demonstrate the substantive breach in relation to humane treatment, but the lack of medical evidence was relied on by Justice Martin to say, well, you haven't adduced enough evidence to show that you reached that higher threshold of the breach of Section 17, which is in relation to inhumane and degrading or treatment or torture. The Human Rights Commission's counsel argued, and we argued, that there's someone being in solitary confinement for 8 years should be sufficient to demonstrate. And there was some international case law that was pointed to say the court can accept that it's universally acknowledged that this is going to reach that threshold of human suffering. But Justice Martin's view was, well, if you wanted to demonstrate the effects of isolation in a prison environment, then appropriate expert evidence should have been adduced. So he made that finding at paragraph 161. So there was an impact of not having that lack of medical evidence, but there was also an impact of having that affidavit from Mr. Owen Darcy. So I guess my takeaway from this is it's really important to be thinking at an early stage about what you can adduce, how you can adduce it, what kind of material is going to be relevant, because that, particularly in cases of substantive breaches, I think is really important. And that's my 10 minutes.
Thanks so much, Helen. And I think what's important to note for people who might not have a lot of experience in courts and tribunals in raising human rights is that the onus of demonstrating that the human rights has been limited is on the applicant relying on the human right. And then once they've demonstrated to the court that the right has been limited, is that the onus then flips, and it's meant to be on the respondent public entity to then demonstrate that the limitation was reasonably justified. So that's a useful thing to also take away with you today. Before we go to the next section, I thought, Penny, we might just consider whether there's any questions at this stage that we can respond to.
Hey, Beck, I'm just going to have a quick look for you now. Doesn't look like anything's come in from the live session so far, but we definitely have some questions that were people put in when they registered, so we can circle back to those at the end, but nothing so far.
Sure, no problem. Well, I invite people to ask any questions that have come to mind while we've been going through, and I'll keep going with the last part of this presentation, which is talking about where to from here. And so, keeping in mind that the 4-year statutory review of the Human Rights Act has now been announced and the terms of reference have been released, and community legal centres in particular have been identified in those terms of reference as being stakeholders who will be consulted by the reviewer. I thought I'd ask our presenters today to provide any of their perspectives and thoughts about where what the challenges are under the existing Human Rights Act, or where the Human Rights Act could be improved. What are the things that the reviewer perhaps should be looking at when conducting a review of the Human Rights Act? So can I throw that open to Ellie or Helen? I don't know who wants to go first.
I'll jump
Ellie?
in quickly. It's Ellie, and I'll say that the most obvious point, so sorry, Helen, for getting in quick. It's an obvious one, but I think there needs to be a standalone cause of action available.
That's right. I think at least a few court cases I'm aware of have become unstuck where there's been no standalone cause of action. And perhaps with that standalone cause of action, currently under the piggyback provisions, under section 59, it talks about the fact that you can piggyback a human rights complaint onto an existing cause of action. But if you are successful on the human rights aspect alone and not on the substantive cause of action, there's no claim for damages. So that might also be a barrier, particularly in relation to no-win, no-fee potential arrangements for litigants who might not be able to afford their own representation. So damages might be another feature that needs to be addressed in the review. Helen, did you have any thoughts about what you've encountered? Or Ellie, sorry, I can see you might have. Either one, do you have any other thoughts?
Yeah, look, I mean, sorry, you go, Ellie.
No, you go.
I mean, yeah, I think obviously the standalone cause of action is the dream. Something I've noticed, I haven't done many conciliations. I've only done 2 human rights conciliations, which have both been bare human rights complaints. And I think the reason a lot of our clients don't do them, well, I guess the reason we don't do them is because actually a lot of our human rights advocacy results in a good outcome for the client at an early stage. So I've been pleasantly surprised by how often advocacy submission to a public entity has resulted in us getting the outcome we want for the client. And I certainly have seen where we have done a submission that hasn't worked, and then we've advised them that we're going to the commission. Then at that point they will go back and revisit it because they don't want to be before the commission, even though there aren't any massive consequences if the conciliation doesn't settle. But I've also been interested in the human rights conciliations we have done. Both of them had reports written, because neither of them resolved, and both of them had reports written by the commission to provide, I guess, some guidance, which is the most you can ask for, really. I mean, you can ask for anything in a conciliation, but in terms of if it's not going to resolve, you can ask the commission to publish a report. The commission can decide whether they do or not. But again, interestingly, in one of the complaints we did, the fact that the commission said that they were going to publish a report resulted in the public entity shifting their position somewhat and agreeing to review policies and procedures when they hadn't been so willing until the report had occurred. So I think it's I have been pleasantly surprised by how much the existing machinery does help achieve outcomes. But I think if there was anything that could make bare human rights conciliations have greater consequences if they didn't resolve, that would be really helpful. But I have been pleasantly surprised by the impact of the report that can be published.
I was just going to pick up on what you said, Helen, there about consequences and, perhaps the Commission could wield a bigger stick than just preparing a report. I think if there were some other remedies available, there might be a bit more incentive for public entities to engage in human rights complaints and resolve them. Our experience has been a little less positive using human rights arguments. And that tends to be because we're focusing on the other contraventions, given that it's a piggyback, but it would be great to see some additional remedies available.
I think the other sort of reflection I have on the conciliation versus the litigation route is that the litigation route for us, at least in most cases, but not all, has resulted in a good outcome for the client, but hasn't made a dent in systemic practices that we have concerns about. Whereas the conciliation process gives you the opportunity to ask for broader changes rather than focusing on a particular decision for a particular individual. Now, I'm not saying that the conciliation has resulted in massive systemic changes, but it at least enables you to try and address broader systemic issues. So yeah, I think anything that can help to address systemic issues, it would be really a good thing as well.
Absolutely, definitely agree. And Beck, if I can, maybe this is probably more a criticism of the conciliation process, but I would say where there is a piggyback human rights argument, the human rights issue gets sort of minimal airtime in that conciliation process, and maybe the Commission and advocates could be better prepared to engage in that human rights discussion during conciliation, so we get those structural kind of systemic outcomes that Helen was talking about there.
Thanks for both those reflections. That's really helpful. One of the things I was just thinking about is that conciliation of human rights issues is a bit of an experiment in Queensland. The other states don't. Well, the ACT has just enacted a similar complaints model to ours, and so that's still a wait and see how they go. But we were the first to have that standalone complaint model, so it's been a bit of a try it and see. So it's a really good opportunity, this 4-year review, to try and see, to have the time to reflect on how it's worked and how it could be made better. And then the other thing that I was thinking about is the standalone cause of action. That there is a standalone cause of action in the ACT that you can bring a breach of human rights complaint direct to the courts. And I think from memory, it hasn't had a lot of take up in that jurisdiction. It might just be because it's a very small jurisdiction, but that's another thing that would be good to unpack in the review and to see whether something like that is appropriate in Queensland. Penny, was there anything in the comments before I move on to the next question?
Yes, Beck, we've had quite a few questions come in while that chat was happening. So the first one is from Ferdy at No More Legal. Are there cases where public authorities have been penalised for breach of human rights? So
I guess what you mean, what do you mean by breaches of human rights? Like I said before, so for example, if you are just complaining against a public entity at the Commission level, so it's only a complaint to the Commission where we conciliate it, I guess it's up to the parties to decide how they resolve that issue, and it could be agreeing to change the decision, it could be agreeing to change processes or policies that impacted the decision. It could just merely be an explanation of why they took the decision that they did, and that satisfies the complainant. In terms of coming to court and demonstrating a breach of human rights, I mean, there have been definitely positive cases where the courts have used human rights to come to an outcome that benefits the complainant, but if there is a human rights component, it rarely results, or certainly in piggyback cases, it can't result in a damages payout or financial payout to the applicant. But there are certainly human rights decisions out there where there has been a beneficial outcome for the complainant. So I hope that helps a bit.
Great.
Can I just add, actually, Beck?
Yes,
it's not really it's not a traditional penalty, but if you run a judicial review that's successful, that usually costs will follow the event, is the legal lingo, which means like in our case with Owen Darcy, corrective services had to pay a costs order because the case was successful against them. So that cost them money. It just wasn't money that got paid to Mr. Owen Darcy. So you could perceive that, I guess, as a penalty on the public entity, in the fact that they did have to pay out money. They had to pay our barristers because they'd been acting on a speculative basis in a judicial review application. So they were able to recover costs. Costs were able to be recovered, which were not insignificant because of the amount of work. So that is, I guess, some incentive for a public entity to not go to court.
Yeah, that's an excellent point, Helen. Thanks for that. And also on the next slide, I've got links to, we do summarise the key human rights cases that are decided in Queensland, and there's a link to on the next slide to those lists. So maybe running your eye over those case examples might be of assistance.
Great, thanks, Beck. So the next question comes from Erica. How many Human Rights Commission matters are referred to QCAT? Does the Human Rights Commission ever not refer a matter to QCAT where the complaint is not sufficiently made out?
So the process in referring a matter to QCAT under the Anti-Discrimination Act, so remembering that a Human Rights Act complaint can't be referred to QCAT, but anti-discrimination complaints that are accepted by the Commission have not resolved at conciliation, the complainant can elect to have that matter referred, and we don't have it. There's no discretion on the Commission to say, no, you can't have that referred. Once we've accepted the complaint, then it follows the process of going through a conciliation, and if it's unresolved, it will go to QCAT if the complainant elects, or if it's in an employment matter, it will go to the QIRC. I hope that answers the question.
Okay, great, thank you. Now I need to apologise. I'm not sure that I'll get the pronunciation of the name right here. Aolele has asked, presumably, does the Human Rights Act also apply to the not-for-profit sector, or is it only applicable to public entities?
Great question. I can't provide a hard and fast answer to that. If you look at Section 9 of the Human Rights Act, it defines what a public entity is. And so the not-for-profit sector, including community legal centres, might be what is known as a functional public entity under Section 9 sub 1 sub H, and that's defined as an entity whose functions are or include functions of a public nature when it is performing the functions for the state or another public entity. So so we know that government is a public entity, departments are a public entity, local governments are a public entity, ministers are a public entity, and then there are these people who, sorry, not people, there are these entities which who, if they're seen as providing a public function and who are seen as doing that on behalf of the state, will be considered public entities for the purpose of the Human Rights Act and are obliged to follow the obligations under Section 58. So that's my sort of answer, not answer. Ellie, did you want to add something to that?
Yeah, I was just going to jump in and say for us at Basic Rights, we see that where it might be a private company that are funded to provide like public housing, or sometimes this crops up in the NDIS space as well. So that's where it might, the functional public entities are relevant for us.
Yeah, NDIS service providers are specifically provided for under Section 9 subsection 2, so that's really good to know. And also there's a lot of housing, not a lot, there's a few housing cases that turned on whether the housing association was a public entity or not from Victoria, and they're really instructive as well.
Great, thank you both for that. The next comes from Sarah. Great presentation and examples from the CLCs. She's got two questions for you, Beck, please. One, with the current independent review of the Human Rights Act, how could disability advocacy organisations get involved in the consultation and the conversation? There is a lot of experience on the ground that could enrich the conversation. So maybe we'll respond to that first, and then there's a second question as well.
Wonderful. Look, I'm sure, I hope, so we, unfortunately, well, not unfortunately, the Commission isn't, will probably be providing its own submission to the reviewer about the 4-year review of the Human Rights Act. So an independent reviewer has been appointed. You might be aware that Susan Harris-Rimmer, who's an academic from Griffith University, and I think has had a long association with human rights and certainly the development of the Queensland Human Rights Act. She is just getting started, so hopefully this is a watch this space, and we will try and push out anything we know about the review to community legal centres and any other stakeholders to make sure that the community legal sector's voices are heard, because it's really super important, and it's great to hear that the disability sector is really interested.
Great, thank you. So the second part of her question is, do you think the DRC recommendations will be considered for the purpose of the independent review of the Human Rights Act? There were some strong recommendations made by the commissioners, including a Federal Disability Rights Act. Do you think this could be embedded in our Queensland Human Rights Act, and would this be the right moment?
Ooh, that's a big question. I'm just trying to remember what's in the terms of reference and whether and what it referred to. I might have to put a pin in that question, but certainly that would be a key issue for the disability sector to raise around what recommendations of the DRC could be incorporated into this review to try and you know, cover off on both at the same time if amendments are to be made to the Human Rights Act. But it's a great thought, and definitely something that should be raised with the independent reviewer.
Sarah, it sounds like your organisation's going to make a great submission to the review.
Well, she's apologised for the big long questions and has really appreciated the response, so thank you. Oh dear. So that's the end of the questions that have come through.
Wonderful.
For the live session. There are some that came through the registration process. So, but if you've got more to go on with, Beck, then let's do that.
Yeah, we've just got a couple of minutes left, and maybe we will have, depending on what Ellie and Helen have to add. So I've just got one last, this is the last slide. It might be a bit, I didn't realise that the writing turned out like this when I cut and copied it into the slide, so apologies for that. But you do have a copy on your, that's accessible, and all those links are accessible, and those are the links that I commonly go to when I'm doing my work, so I thought they might be useful to share with today's participants. But my questions for Ellie and Helen to finish off are, do you have your top 1 or 2 tips for advocates using the Human Rights Act?
Thanks, Beck. I'll jump in quickly. It's Ellie here. Top tips are raise the human rights argument really early and be as specific as possible in the complaints. So detail any potential outcomes that are being sought. It's much easier to get them resolved if you're really specific at that point. They're probably, that's a big one.
My tip, I guess, is if you're considering doing piggybacking in any kind of court or tribunal, it's a great idea to get counsel. Obviously, if you're in the Supreme Court, you're definitely going to want counsel. And my advice is try and brief 2 counsel, at least one being an expert in the cause of action that you're relying on. So if you're relying on judicial review, brief a barrister who is an expert in administrative law. And then your other barrister can help with the human rights arguments, or they can work on it together. But having 2 counsel will, because there's so much extra work involved in doing a human rights piggyback, you're going, even what I would call a normal JR, a standard JR that you might only need 1 counsel for, with human rights argument you're gonna need 2, or it'll be better to have 2. Brief people who are experts in the cause of action that you're running and who also have human rights experience, and have really early discussions with them about what kind of evidence do you think we should be adducing and when, because it's time consuming to gather it. And yeah, and often if you are arguing human rights breaches, you may want to try and have the case progress as quickly as possible. So you don't want your case to be delayed by the fact that you're trying to gather more evidence. So those are my tips.
Great. Thanks so much, Ellie and Helen, for your time today and taking the time to prepare for today's discussion. And Penny, I think it's back over to you. I think we finished this conversation right on time.
Yeah, great. Thank you so much to the three of you. That was awesome and well done to finish in such a timely way. What I might do is I'll share the questions that we received through the registrations with you, Beck, and if you were able to provide some responses to those, then I'm happy to share them with the group in due course. But that does bring us to the end of today's webinar. So a huge thank you again to Rebecca, Ellie and Helen for sharing your expertise and your experiences using the Act. I think it's been a really compelling session and so great to hear all of that practical information. So thank you very much. Thanks also to all of you for your questions and engagement. We had a really good turnout for today's session, which is terrific to see. Before you go, just a reminder, complete the feedback survey that'll pop up on your screen once the webinar is closed. It does help us to continually improve our webinar program, and I know that our presenters really like to receive the feedback. So that's it from us for now. Thank you very much again. We hope to see you at our next CLCQ webinar. Thanks, everyone.